Good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Kyle Holland, Gary McKeever, Jerry Brown, James Arnold, Jody Denton, Douglas English, Miranda Hatton, Shane McLeod. I understand that Mr. McLeod is in court in Rains County. We'll recall his case. Linda McFerrin, Jarek Munns. Mr. Munns will be appearing via Zoom today with court's approval. We'll recall that case. Eddie Pate, Eddie Inzar Pate. Okay. John Tadlock, Misty Tadlock, Brian Walker, Martin White, Ray Williams. Mr. Williams is on Zoom and is appearing via Zoom with court's permission. Cedric Thompson, yes, ma'am. We'll recall that case. Vincent Alford, Brandy Ross, Keith Solis Brown, Marty Hedden, Jose Salazar, Jennifer Schaefer, James Burleson, Anthony Fernandez, James Fontenot, Wilford Moore, Jimmy Don Pickens, Richard Strange. Is there anyone in the courtroom your name's not been called and you expect to be on the docket? All right, seeing no one. Do we have any counsel that's ready? All right, may approach. You want this off the record? This is cause number CR 25-31, State of Texas versus Jerry Don Brown. Mr. Brown, the state has filed a motion to dismiss citing insufficient evidence in your case. The court is granting the state's motion. You are free to go. If you want a copy for your records, hang out in the hallway and we'll get you a copy soon, okay? Otherwise, you're free to go. Thank you, Mr. Harden. You ready? What are we calling clients? Are we doing what conference? What are we doing? I mean, is that the only one you had today? I thought I saw you. Okay, that's.
I think it was on for another one.
All right, let's talk about this real quick. Good morning, Mr. Williams. Can you see and hear me? I'm going to ask you to unmute your device. There you go. Can you see and hear me, Mr. Williams? If you're connected to your in-car audio, you need to disconnect. We're not getting any audio from you. If you are connected to your car's audio system,
it won't
need
work.
to
I got.
okay,
Yes,
I've
sir.
got
Sorry.
you now. All right. Can
Sorry
you see?
about
It's okay. Can you see and hear me okay?
Yes, sir. Now I can.
All right. Can you see your attorney, Mr. Schmidt, also? If you can't, you may have to swipe left or right on your screen to see other participants.
Yes, sir. I see you.
Excellent. Okay, Mr. Williams, I'm going to call your case. This is cause number CR 24-226, State of Texas versus Ray Anthony Williams. Mr. Williams is set for jury selection and jury trial next week. And today, this court is entertaining the defendant's motion to withdraw as counsel filed by Mr. Schmidt. Mr. Schmidt, go ahead.
Yes, sir. I've been representing Mr. Williams from the initial appointment. It's been quite some time. We've been set for trial, I believe, a couple of months. As I was reviewing discovery on this case in preparation for trial.
I don't think he can hear you. Mr. Williams, can you hear Mr. Schmidt?
Yes, sir. I'm just making sure I hear everything.
Okay, go ahead.
In preparation for trial, I discovered that Jonathan Manning, who offices with me, was the co-defendant's attorney. After I discovered that, and it was on a piece of evidence that wasn't disclosed on the initial discovery response. The DA's provided it when they made it, but I hadn't gone back and reviewed it. So when I reviewed it and realized that Mr. Manning was on the video recording with his client, it had an appearance of conflict. Technically, it is a conflict. Under those circumstances, I made Mr. Williams aware of it. We watched the video together. I gave him his legal options as it pertains to Rule 106 of the disciplinary rules of professional conduct. And at that point, he advised me that he wished to assert his right to and did not wish to waive the conflict. In response to that, I filed the motion to withdraw, and that's why we're here.
Mr. Williams, were you able to hear everything that Mr. Schmidt said regarding the motion to withdraw?
Yes, sir, Your Honor.
And is that your position today that you're wishing for Mr. Schmidt to withdraw due to the conflict of interest?
Yes, sir.
Okay. Any position by the state?
No, Judge. Briefly, that what Mr. Smith said is accurate. This is discovery that was produced, was made during the course of us preparing for trial, interviewing a witness. And we did release it to him back in July, shortly after it was made.
All right, then the court grants the defendant's motion to withdraw as counsel. The court discharges Mr. Schmidt as counsel. Mr. Williams, I'm going to have to, due to your indigency, find another attorney to represent you. Are you still indigent at this time, or do you believe that you can hire an attorney to represent you in this matter?
Well, I'm still injured at the time, sir.
Okay. All right. So, Mr. Williams, I've granted the motion to withdraw. I will appoint a new attorney. Once I have that information, Ms. Abraham will forward that to you. We'll also provide it to Mr. Schmidt so that he can also provide it along with any of the discovery that he has to your new attorney.
And Judge,
Yes, sir.
it's still set on jury selection docket for Monday. I made him aware that that setting is still good and that he needs to sign a reset unless the court resets him today.
Mr. Williams, you're set for jury selection on Monday, the 22nd. That's next week. You're
Yes, sir.
still required to appear. All right, check in with the pretrial release officer, and we'll have a reset notice for you on that day. But you're still required to appear in court on Monday. You understand?
Yes, sir.
All right, Mr. Williams.
Yeah, Your Honor.
Yes, sir. Go ahead. Yes, sir. Go ahead.
I'm hopefully, you know, what I mean, I should, but you know, Monday I should be back. But you know, I'm up here at Cook's, and they admitted my son. I got an infant child, and we just don't know what's going on yet. We still waiting on a bunch of blood work and everything coming. But I should be there Monday regardless of fact. So is it a certain time I need to be there?
Yes, 8:30. If something develops between now and then, just contact the court, leave a message, send an email, do something, and
Yeah.
we'll work with you. Okay.
I sure appreciate you.
You're welcome, sir. We'll see you Monday.
All right, thank you.
All right. We have any other counsel that's ready? Yes, please. Will you move that microphone back over there? Good morning, sir. Doing good. All right, Ms. Ross, Brandy Ross, cause number CR 25-39. Here you go.
Thank you, sir.
And we'll be at the podium right there. It's all right. All right, this is cause number CR 25-39, State versus Brandy Nicole Ross. We're set for pretrial. Mr. Todd, any announcements?
Yes, sir. Court executed my motion to substitute on September 12th. I talked with prosecutor today. I have something of a portal, of course, and ascertain the discovery, and of course, review of that being the case, I'm asking for the pretrial, see if there are any political motion that I see.
Mr. Todd, you available on October 16th?
Can I check this?
Yes, sir, please.
Does I have some cases set in Denton County that day?
What about October 14th?
Yes, I can do
Good. All right, court sets Ms. Ross for 9 a.m. October 14th for pretrial. And once she signs her notice, she'll get the yellow copy, white copy stays with me, and then she's free to go. You're welcome. You're welcome. Good to see you. You ready, Mr. McKeever?
Yeah.
Mr. McKeever, this is cause number CR 25-81, State of Texas versus Gary Ray Van McKeever for pretrial. Mr. Brighton, go ahead.
Judge, we resolved any issue we have discovered. So we need that.
Just ready for me to set it for docket call, so you have time to determine if you want to accept a plea agreement or not. All right, court will set Mr. McKeever. Mr. Bratton, are you available on October 16th?
I am.
All right, court sets Mr. McKeever then for docket call October 16th. And so on that day, Mr. Bratton, I will expect your client to have made a decision if this case will resolve by plea agreement or by trial.
Thank you, Judge.
You're welcome. Mr. Manning, who are you ready on? Arnold? Mr. Arnold, if you'll come forward, sir. This is cause number CR 25-117, State of Texas versus James Douglas Arnold. Yeah, come on up, sir. Yes. Yes, that's fine. And if he needs to sit, Mr. Manning, you can grab him one of those chairs.
Judge Arnold, and it's spelled correctly, he understands the charge against him was already punishment. At this time, we plead not guilty and request to be set on the pretrial.
Court does enter Mr. Arnold's plea of not guilty into the record, finds that he's waived the formal requirements of arraignment. Court sets Mr. Arnold for pretrial. Is October 16th too soon, Mr. Manning?
Judge,
Okay, court sets Mr. Arnold then for pretrial October 16th at 9 a.m.
there's additional regarding his TRN.
Yes, sir. Mr. Arnold, when you were arrested, I'm presuming that you were not arrested in Van Zandt County. Is that correct? You were arrested somewhere else? Hunt County, okay. Because you were arrested outside of the county, Van Zandt County does not have a copy of your fingerprints that they are required to take and report to the state of Texas. So I'm going to order you to go out to our Justice Center out on Highway 64, and I have an order there. You're going to take that order, and they just need to take your fingerprints, and that's it. They're going to take your fingerprints so they can comply with the law. They're not going to put you in custody or book you in or do anything like that, but they are going to take your fingerprints, and then you'll be on your way, okay? So I want you to go take care of that as soon as you leave court today, and you got to have your ID along with that order right there so they know why you're there. Does that make sense? Okay.
Judge, the next one, Mr. Denton.
Jody Lynn Denton, CR 25-145. Ms. Denton is set for pretrial today.
Yes, Judge, Mr. Denton had previously waived arraignment, however, we need to go over pretrial and they're still waiting on an offer. Request for additional pretrial to discuss those matters.
Any objections from the state?
No,
All right, court grants the request, recess Ms. Denton for an additional pretrial October 16th at 9 a.m.
Judge, next ready on Miss Hatton, I'm sorry, Hatton.
Miranda Ann Hatton, CR 25-146. Ms. Hatton is set for pretrial.
Yes, Judge, we have no pre-trial issues this time. I have had a chance to discuss the survey with, Ms. Hatton. We don't have an offer at this time, but I requested an offer. We guys do something about.
All right, court sets Ms. Hatton in for docket call October 16th at 9 a.m. If the state is going to make an offer to Ms. Hatton, if you'll make that well in advance so that she has time to consider that with her attorney and make a decision on that date. Is Mr. McLeod here yet? He is not.
Mr. Fair.
Linda Mabry McFerrin. All right, Ms. McFerrin is set for pretrial today, Mr. Manning.
Yes, Judge. Mr. Fair, I had the opportunity to go over the discovery. She has provided me information about these have done so. We received an offer on her case and discussed that offer. At this time, the request was set on call.
All right, court sets Ms. McFerrin for docket call October 16th at 9 a.m.
Or the 16th, Judge.
16th. And once she signs, she's free to go, Mr. Manning.
Thank you.
What about the Tadlocks? You ready on the Tadlocks? Let's do the Tadlocks. John Michael Tadlock. Mr. Manning, you're representing both Mr. and Ms. Tadlock, is that correct?
I made forward that both the talents were an agreement to waive the conflict of representation. As they're going to be, the defenses they share was shared. So they have both agreed to
Are you making a similar announcement on both?
Yes, Judge. So on my power case, there is a lot of.
Well, let's do this then. Ms. Tadlock, come on up. I'm just going to call them all at the same time. This is State of Texas versus John Michael Tadlock and State of Texas versus Misty Amber Tadlock. All right, Mr. Manning, I'm sorry to interrupt. Go ahead.
That's, my clients have both provided me with a significant amount of financial documentation regarding the allegations. And I have yet to come have people take the case on, break down our offenses and litigation. I have asked for additional trial for me to be able to do that. I think it'll be possible for some reason.
Any objection from state?
No.
All right, court, how much time do you need, Mr. Manning?
Judge, due to trial schedule, it's all I have a little bit longer just to compile. Like I said, it's gonna take a half and we won't sit down and discuss it.
About October 30th. It's the evidentiary docket date.
Yes, that should work.
All right, court sets both Mr. Tadlock and Ms. Tadlock for pre-trial on October 30th at 9 a.m. You ready on Mr. Brian Walker?
Yes, Judge.
Brian Joseph Walker? No, sir. No, sir. No, sir. I doubt when you go to the club, you're able to do that, are you? That's a good answer. Come on up. Come on up. Now hang a hard right. Hang a hard right. You're gonna make me have to put a bouncer right there, you know? And if we put a bouncer there, we're gonna have a cover charge. I'm just telling you, it's gonna cost. All right, this is cause number CR 24-37, State versus Brian Joseph Walker Jr.
Yes, Judge.
Set for pretrial. Go ahead.
I have to discover and has about issues. Additionally, Judge, we got legal reach resolution requesting set for.
How much time do you need, Mr. Hannon?
Judge, we just have, setting.
I've got another setting on Tuesday, the 30th or 2nd of October, Thursday. That'd be the next Thursday.
Judge, if I may. He's gonna.
Sure, sure.
All right. Yeah.
Sure.
Judge. Check this.
You're likely to be here on 10-2.
Yes, Judge. I'll leave it.
10-2? All right. Court sets Mr. Walker then for plea October 2nd at 9 a.m. I'm presuming it's a 9 a.m. plea.
Yes, Judge.
Okay.
Thank you, Judge.
You're welcome, sir.
Judge, I also believe I have Mr. Martin White.
Martin Lee White. This is cause numbers CR 25-148, CR 25-149, set for pretrial. Go ahead.
Yes, Judge, I have a disagreement on issues, however, I am still waiting an offer. So I can either be set up call or have to be shown for this.
You want that October 16th date?
Yes, Judge.
All right. And you said docket call?
Yes, Judge.
All right. Court sets Mr. White for docket call October 16th, 9 a.m. You're free to go, sir. All right. You want to check on Mr. Munns?
Oh, we also have. Well. The state.
Is Eddie Pate here? Eddie Pate? Not yet.
Judge, I don't have paperwork at this point, so I may, say that.
Sure. Yeah. Let me know what you find out on Munns.
Thank you.
Good morning. I'm doing good. It's Lukanen, is that correct? Okay. And is it Lukonen? I'm sorry? Lucan? But not that close. All right, Vincent Alford. Come on up, sir. All right, Mr. Alford is set today in cause number CR 25-101 for pretrial. And Ms. Lucan, you are standing in for Mr. Strife today. Is that correct?
Reviewing the whole evidence, the deliberation, we had discussions, we're just attending according to that with all our staff. So I would ask if we could have one additional pretrial, we would appreciate it.
Any objections?
No objection, Your Honor.
Would October 16th be available? Is that enough time?
I think so.
Okay. All right, court sets Mr. Alford then for pretrial October 16th at 9 a.m. Yes, ma'am. Thank you for being here. Appreciate it. You too. Patty, where? Keith Solis Brown, CR 25-68, CR 25-69. Mr. Brown is set for docket call today. Court understands that retained or appointed counsel, Mr. Jeff White, is unavailable today. The court recognizes the Honorable Nolan White is standing in for Mr. Jeff White. Due to the issues with Mr. White, Jeff White, court is going to reset Mr. Brown's case, which is currently set for docket call. Mr. Brown, I'm going to reset you to October 30th to give you and your attorney, Mr. White, more time for him to be here to take care of business for you. Okay? You're welcome. You're free to go. Yes, sir. You're welcome. Marty Lynn Hedden. This is cause number CR 25-10 and FC 25-55. Mr. Hedden is set for docket call and pretrial. Mr. Hedden, I'm going to reset your case for the same reasons that I told Mr. Brown, so that Mr. Jeff White, who's got issues and cannot be here today, I'm going to reset you to October 30th for docket call and October 30th for pretrial for Mr. White.
Okay, and
And Mr. Hedden, I don't like reading the newspaper on Monday morning and finding out you get rearrested while you're on bond. I know you've re-bonded in this case. If you touch alcohol while you're on bond in this case, I'm gonna lock you up and you will not get out until your trial is had. Do you understand? Am I being crystal clear?
Yes, sir.
And this is Mr. West. I'm about to tell Mr. West to be on you so hard that you couldn't drink and get away with it. I'm about to tell him that right now. I'm gonna have him call you into the office every day to drug test you. I'm gonna have him call you into the office every day to drug test you. I may get a sober link and put it in your house. I don't know. I'm gonna prevent you from continuing to drink. If you're not gonna do it, then I'm gonna do it because it's my job to protect this community. You understand? So you've made a big impression on me, and it's not a good one.
Yeah.
So I hope that you can do yourself a favor and do your attorney, Mr. White, a favor and quit making his job so hard. You understand? All right, we'll see you back on October 30th. Jose Salazar, CR 25-84. All right, Mr. Salazar is set for docket call today. Mr. Salazar, I'm going to reset your case to October 30th for docket call so that you and Mr. Jeff White can appear together and try to resolve this case, okay? You're welcome.
I got it.
Save that for Mr. White. You're welcome. Jennifer Schaefer. This is cause number CR 25-24, State of Texas versus Jennifer Diane Schaefer. We're set for pretrial today. Mr. White's not able to be here. Court is going to reset you to October 30th for pretrial. And once you sign, Ms. Schaefer, and get your notice, you're free to go. Thank you, Mr. White. Appreciate it.
Your Honor, I've got to please take up my case.
Sure. Yeah. Who would you like to call first?
Oh,
James Darrell Burleson. This is cause number CR 25-92. We're set for docket call. Go ahead, Mr. White.
Your Honor, just
All right. Was there an offer that was extended by the state that Mr. Burleson's rejected? How much time was that? 10 years? All right. All right. Court finds that Mr. Burleson has elected to have a jury trial on this case. The court will set Mr. Burleson for jury selection beginning October 6th. That'll be at 8:30. So, Mr. Burleson, when you arrive, you'll meet downstairs. My court staff will be down there to assist you. You won't report to the courtroom because you're not going to go to trial on that day in all likelihood, based on other cases that are scheduled for trial. So you'll meet downstairs. Pretrial release officer will be down there, and we'll give you more information. Okay. Who's next?
This is,
James Owens Fontenot. All right, this is cause number 2025-346. Cause number 2025-425, CR 24-258. I show that we are set for docket call on the assault, third degree. Got a note, Mr. White, you don't believe that Mr. Fontenot has been arraigned on his driving without financial responsibility with an accident involving serious bodily injury or death, and then we're set for pretrial on the Class A misdemeanor assault. So let's go ahead and arraign him then on the Class A financial responsibility.
Your Honor, this time, we want to read, final first name. He were.
All right, court finds that Mr. Fontenot has waived the formal requirements in cause number of arraignment in cause number 2025-425 and enters his plea of not guilty into the record on that charge. You want me to set these for pretrial again?
Yes, sir. Now, I talked about this situation, Your Honor. Our intent is to try to get everything wrapped up in equal love.
Okay. All right, court will set Mr. Fontenot. Are you available October 16th, Mr. White? All right, court sets Mr. Fontenot for pretrial October 16th and docket call on the third degree assault October 16th. I'm happy to be going home. Mr. White, who's next? Got Pickens, Jimmy Don Pickens, CR 25-102. All right, Mr. Pickens is set for a docket call.
Your Honor, this time. Drug it. It stays off, I here. And.
All right, and you've counseled your client that the court may not allow him to enter into plea agreement after the state. All right, court sets Mr. Pickens in for jury selection beginning October 6th. And so, Mr. Pickens, you'll arrive at by 8:30 and meet my court staff downstairs. If your case gets in the top 10, you may be liable for trial that day. If you are set in the top 10, then I'll notify your attorney. You ready now, Mr. Strange? Richard Thomas Strange, CR 25-104. All right, Mr. Strange is set for pretrial.
Your Honor, we had this. Then.
All right, court sets Mr. Strange then for docket call October 16th at 9 a.m. Strange. Mr. Strange, the pretrial release officers need to meet with you before you leave.
Continues.
Yeah, just come over here, see what they need. Is Eddie Pate here? Okay, hang on. That's okay. Not yet. I just want to make sure you're here. I had marked off on my docket to issue a warrant because you were late. Mr. Munns. Sure. What about Shane McLeod? Shane McLeod here? Hmm? Hmm. Not yet. I was just seeing if he had arrived late. All right, this is Sanctions Court hearing, cause number CR 20-291. State versus Kyle James Holland. Mr. Holland, you're in Sanctions Court today. Their last court session ordered you to pay $60 to probation. You complied with that. I ordered you to pay $170 to court collections, and you complied with that. We've been keeping you in Sanctions Court to see if you would stop smoking marijuana. And due to the admission today that you have consumed marijuana yet again, you're not going to be getting out of Sanctions Court anytime soon. I mean, you probably had one more month of Sanctions Court and I was going to release you because I would have had at least 3 months of you showing me that you weren't going to smoke weed or whatever else you're doing, THC through a vape, whatever it is. And so today, because you have admitted, the court is going to sanction you to serve 3 days confinement in the county jail. Court has signed that order. You know the drill because you've done it before. So you're going to appear at the Van Zandt County Justice Center with your ID and this order of commitment. So Mr. Holland, I don't know what else to do with you, but I think what I'm going to do, because we've tried to talk about it, and you tell me that your freedom and liberty is more important than marijuana, yet you keep proving yourself wrong. So let's just go ahead and make this a day that I tell you that there will not be any more sanctions for marijuana. There will be no more sanctions. There will be no more smoke weed, do 3 days. There'll be no more of that. You test positive for weed again, you smoke weed, you admit to weed, you do any of that, I'm telling the probation department that you're no longer a good candidate for community supervision. And I'm going to direct them to file a violation report with the state of Texas, who will then make a decision whether or not you should be filed upon. And if so, they come in here and prove this, and it's going to be pretty easy to prove this because you've admitted it. Then what we're looking at 2 to 10 in prison. That's what we're going to do. All right, I'm tired of the revolving door. I'm gonna reset you for sanctions court. October 16th. I'm gonna order you to pay $60 to probation. And $170 to court collections. And have that paid the week prior to, or at least the Tuesday prior to, preferably the week prior to the 16th, okay? All right, ball's in your court. I want to see if you're gonna dribble it or you're gonna dribble it out of bounds. Oh, yes, sir, you're free to go.
Mr. Hall. Wait out in the hall, and you'll get a copy.
Mr. Manning, you ready or you still need time? I can stand in recess if you need time. All right, court's gonna stand in recess for 30 minutes. We'll resume at 10:30.
These things, I was just testing to make sure.
having some planning on this shit. Mic test. And it's voting on mic test. Run the history judge and now slash elected IT, or IT, I should be, go along with it. Non-expert, audio, mic test, council table, mic test.
Judge, I can barely hear you.
Test 1, 2, test, test.
Wait, Nat, can you hear that? Is
Yes, sir, I did.
that much better?
Yes.
Okay, I think it was a Zoom setting. So,
Oh, okay.
okay. All right,
Right.
thanks. Mr. Manning, who are you ready on?
Judge, ready, I'm Mr. Pate, Eddie Pate.
Mr. Pate. This is cause number CR 25-83, State versus Eddie Nunzar Pate for pretrial. Go ahead, Mr. Manning.
Judge, there's a pretrial issue we have brought up to the state. We are still waiting a follow-up on that. Request for additional pretrial.
How much time do you need, Mr. Manning?
Judge, I'd be fine with an additional month. I'm not sure how long the state would need.
Your Honor, I've been meaning to get to it. I just haven't been able to yet. Should be able to get to it within 30 days.
All right, court sets Mr. Pate for additional pretrial October 16th at 9 a.m. Pate court, 9 a.m. sharp.
Yes, sir.
I'd already written down, issue a warrant. For Manning, he interceded on your behalf, told me you were running late. I appreciate that, but I want you to leave, that you have enough time to where we're not having to wait on you.
I appreciate that. Thank you. Every day. Judge, next ready on Mr. English.
Mr. English, you'll come forward.
May I approach, Judge?
Yes. This is cause number CR 25-21, State of Texas versus Douglas Heath English. All right, Mr. English, I'm going to have you placed under oath if you'll raise your right hand. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Yes, sir. All right, you can lower your hand. All right, Mr. English, I believe that in this cause number, you are set on this court's jury trial docket. And today it indicates that you want to enter into a plea agreement in a DWI felony case that's filed at the county court at law. And you want to waive your right of trial in this case. Is that correct? Okay. And you understand that once you waive your right to a jury trial, that right may not be given back to you. Yes, sir. Meaning that you can't have what's known as buyer's remorse, making a decision and then regretting that decision and seeking to change it. Do you understand that you and only you can waive your right to a jury trial? Your attorney can't do it. The court can't do it. And if you do elect to waive your right to a jury trial, you have to do so intentionally, knowingly, and voluntarily, meaning that you're doing it of your own free will after understanding all of the ramifications of the decision. You understand that? Yes, sir. And in this case, you're asking the court to allow you to waive your right to a jury trial, and you've discussed this with your attorney, Mr. Manning. Is that correct? Yes, sir. And Mr. English, has anyone threatened you, forced you, or pressured you to waive your right to a jury trial in this case? No, sir. No? No, sir. Okay. Mr. Manning, you've counseled Mr. English on what it means to waive his right to a jury trial?
I have, Judge.
And you believe that he understands that right and he is still wishing and desiring to waive intentionally, knowingly, and voluntarily?
Yes, Judge.
Mr. Harwell, on behalf of the state, you are also asking the court to allow the state to waive its right to a jury trial?
Yes, Your Honor.
All right, then the court will grant and approve the waiver of jury trial in cause number CR 25-21. It's my understanding that Mr. English is going to resolve a case down in the county court at law, and that this case here will be taken into consideration with that plea. Is that correct?
That is correct, Judge. Judge, I don't know if we need to have a status on him in the future, if the court would like for him to be set after our plea date, or if we were fine with just going forward with.
When is your plea date in the county court of law?
November 3rd, Judge.
November 3rd. All right, let's set Mr. English, and then obviously if you resolve business down there, it will be an issue. Let's set him in this court status Thursday, December 4th.
Judge, I apologize. My docket does not have his case number for this.
CR 25-00021.
25?
21.
21. Okay, thank you, Judge.
21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21
Last judge, I have Mr. McLeod. Sorry, not last, but last here in person.
Mr. McLeod, this is cause number CR 25-98, State of Texas versus Shane Albert McLeod, and we're set for docket call. Mr. McLeod, were you able to attend the Rains County Court?
Yes, sir.
All right, very well. Go ahead, Mr. Rains.
Judge, with his Rains County business taken care of, I am going to be meeting with Mr. McLeod before our next setting on October 16th. We're gonna be meeting on the 10th to go over the state's offer as well as discovery in light of the resolution of his Rains County case.
Okay. Court sets Mr. McLeod then for docket call December 16th at 9 a.m.
Judge, I'm sorry,
I'm sorry, I said December, didn't I?
yes, Judge.
October. Sorry, I still have my calendar flipped over here to December from Mr. English's case.
Judge, last we have Mr. Munns. I don't know if that phone number is still in there.
I have an individual named Melissa Lee now.
Judge, I believe that is Mr. Munn's girlfriend.
State, can you?
Hello?
Yes, sir. We'll be with you just a moment.
Oh, okay. I'm sorry I've been having a fit with the Zoom, but I'm here.
It's okay. Just stand by. I'll be with you just a second.
I'll be here. Okay.
Mr. Munns, can you start your video?
Okay. I'm ready. Sorry that, sir.
Okay, it's all right. It's all right. All right, this is cause number CR 25-100, State of Texas versus Jarek Chase Munns. We're set for docket call today. Record will reflect that Mr. Munns is appearing via Zoom today with the court's permission due to medical issues. Mr. Munns, your attorney, Mr. Jonathan Manning, is present in the court along with the attorneys for the state. Mr. Manning, Mr. Munns is set for docket call today. Any announcements?
Yes, Judge. Unfortunately, because of Mr. Munn's medical issues, ongoing medical issues, we've been unable to meet and go over the discovery in his case, as well as any potential offers that may have been offered by the state. So we request additional docket call as we're not prepared to announce ready at this time.
Any objection?
No objection, Your Honor.
All right, then the court will reset Mr. Munns for docket call. That will be October 16th. And I'm going to set it for final docket call, Mr. Manning. So Mr. Munns needs to make arrangements to get to your office to go over everything and make a decision if he wants to enter into a plea agreement or request a trial.
Yes, Judge.
All right, Mr. Munns, this will be the only notice you'll receive from the court, October 16th at 9 a.m. Do you understand?
I got it. Yes, sir.
All right, you're free to go, Mr. Munns.
Thank you. Thank you, sir.
Judge, I believe that concludes my business this morning. I'll be excused.
Let me check with my boss. Let me check with our senior regional manager. State Ram, is Mr. Manning free to go? You were late till 1 o'clock. You heard the lady.
I'll make a quick lunch of it.
I forgot what's going on. Thank you, sir. Appreciate it.
Just have a little bit of flashback to,
Who'd you like to call?
We called,
Mr. Moore, a plea agreement? I don't see the plea agreement in my queue. Is that a probation? It's probably. Well, this would be the second. Oh, probably. This.
See, it says this document has already been sold for. This is for names. I don't know.
Mr. White, when did y'all sign Mr. Moore's paper? I've got Mr. Fernandez, but I don't think probation says they don't have Mr. You signed it.
Did you submit them?
I got it back. Mr. Fernandez, come on up.
yes, sir.
We're gonna do yours next while Mr. Morris finishes.
See, that was
Thank you. Yes, sir. Thank you. Yes, sir. Second.
Sergeant Martinez, if you want to go ahead and fingerprint him, you can do
Okay,
that.
come on.
We'll try to save him some time while we're taking care of some meetings. We're doing a little backwards, but it'll all be fine. We're just taking Mr. Fernandez's fingerprint.
I think what, and I apologize, but I think what happened was some probably broken connection. Wow. That's start getting all the return emails, they all look the same.
All right, this is cause number CR 25-73, State of Texas versus Anthony Paul Fernandez. Mr. Fernandez, sir, if you'll raise your right hand, I'm going to place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Yes. All right, you can lower your hand. Just make sure you speak up loudly and clearly for me. Your name is Anthony Paul Fernandez, is that correct? Yes, sir. And Mr. Fernandez, are you a United States citizen who reads, writes, and speaks English? Yes, sir. Have you ever been diagnosed with a mental condition?
I don't know if it's a mental condition, ADHD?
ADHD?
Or
Okay.
ADD.
Well, it could affect your cognitive ability. Are you currently on medication or under treatment for that?
Yes, sir.
You feel in any way that ADHD is affecting your ability to understand what's going on in this case?
No, sir.
Okay. In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White as your attorney?
Yes.
And you understand everything that you've read and signed that's in your plea agreement?
Yes, sir.
Mr. White, do you believe Mr. Fernandez to be competent? And if so, have you explained to him his rights regarding the case, including the advantages and disadvantages of a deferred adjudication plea?
I did, Your Honor.
And you believe him to be competent?
I do.
All right, Mr. Fernandez, you were originally charged with a third-degree felony offense of assault of a family or household member by impeding breath or circulation. I see that your plea agreement is and the recommendation from the state is that you would be pleading guilty to a lesser included offense of assault causes bodily injury of a family member, which is a Class A misdemeanor and does carry a range of punishment should you be convicted and sentenced to not more than 365 days in the county jail and a possible fine not to exceed $4,000. I see the plea agreement in your case. Upon you pleading guilty, the state's recommending to the court that the court consider the evidence but not convict you of the offense. They're asking the court to place you on 2 years community supervision. They're asking the court to assess a fine of $1,500 and order you to attend anger management through your probation in lieu of a batterer's intervention program. In addition to these terms, you would also be responsible for court costs of $270 and reimbursement fees of $35. Mr. Fernandez, is that your understanding of the plea agreement and what you want the court to approve?
Yes, sir.
All right, then understanding those things, Mr. Fernandez, how do you plead to the Class A misdemeanor offense of assault causes bodily injury of a family member? Pleading guilty or not guilty?
Get guilty. I get guilty.
All right, and are you pleading guilty, Mr. Fernandez, because you are guilty of committing that offense? Are you pleading guilty because you are guilty, or are you pleading guilty for some other reason? You need to talk to Mr. Wise.
Okay, I'm sorry.
No, I got you.
Yes, sir. No.
So you're pleading guilty because you are guilty?
Yes, sir.
All right. And Mr. Fernandez, has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
Okay. Court does accept the defendant's plea of guilt. Mr. White, any objection to the stipulation of evidence?
No, sir.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, just a record to reflect that the state is in compliance. The victim was uncooperative in this matter.
All right. Thank you, Mr. Hernandez. Court does appreciate that. Anything further from the defense?
No.
All right, court will consider the evidence. All right, the court, having reviewed the evidence, finds that there is enough evidence to convict the defendant of the offense. The court follows the plea agreement, defers a finding of guilt, places Mr. Fernandez on 2 years community supervision, orders him to pay a $1,500 fine, $270 in court costs, and $35 in reimbursement fees. The court orders him to complete anger management as a condition of community supervision through the Van Zandt County Community Supervision and Corrections Department. All right, Mr. Fernandez, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. you can come on over here and meet with the probation officers and they'll give you more information. When Mr. Fernandez is done, he'll go out the other way. So if you just want to wait in the hallway, he'll be with you in just a moment. All right, this is cause number CR 25-82, State versus Wilford Kenneth Moore. Mr. Moore, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Thank you, sir. You can already. Mr. Moore, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White as your attorney?
Yes, sir.
Do you understand everything that you've read and signed? That's your plea agreement.
Yes, sir.
Mr. White, do you believe Mr. Moore to be competent to enter into a plea agreement? If so, have you explained to him his rights regarding the case, including the advantages and disadvantages of a deferred adjudication plea?
I did, Your Honor, and I do believe he's competent.
Mr. Moore, you are indicted with the third-degree felony offense of evading arrest or detention with a vehicle that does carry a range of punishment of not less than 2 years in prison and not more than 10 years in prison, and a possible fine not to exceed $10,000. The plea agreement in your case appears to be, upon you pleading guilty, the state's recommending that the court consider the evidence, defer a finding of guilt, and placing you on community supervision for a period of 2 years. In addition, you would be responsible for a fine of $750, court costs of $290, and reimbursement fees of $35. Mr. Moore, is that your understanding of the plea agreement?
Yes, sir.
All right, Mr. Moore, understanding the plea agreement and the range of punishment, how do you plead to evading arrest or detention with a vehicle?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
And has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. White, any objection to the stipulation of evidence?
No, sir.
That is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, thank you.
Anything further from the defense?
No, sir.
All right, the court will consider the evidence. All right, the court has reviewed the evidence and finds enough evidence to convict the defendant. The court will follow the plea agreement and the recommendation of the state. Court hereby places Mr. Wilford Kenneth Moore Jr. on 2 years of deferred community supervision, orders him to pay a $750 fine, $290 in court costs, and $35 in reimbursement fees. Mr. Moore, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward, and Sergeant Martinez is going to take your fingerprint. After that, you'll meet with the probation officers.
Thank you.
You're welcome. Thank you, sir.
Your Honor, that's all I have.
Thank you, Mr. White, and I appreciate you helping the court with Jeff's cases. Court has concluded its morning docket. Will stand in recess until 1:30.